Before I ask my questions, I want to take a moment to push back against some of the ridiculous claims that we've heard from the other side this morning, particularly that Judge Koh's decision in the Tandon case was either somehow hostile to people of faith or a radical departure from the law. Colleagues, I invite you to read Judge Koh's well-reasoned and detailed opinion in the Tandon case. If you read it, you'll see that Judge Koh considered and cited precedent from the Supreme Court, the Sixth Circuit, and the Ninth Circuit, consistent with a response she just made to a question from Senator Blackburn. Fact, when her decision was appealed to the Ninth Circuit, two judges, including a Bush appointee and a Trump appointee, agreed with her. In fact, at the Supreme Court, Chief Justice Roberts agreed that the Supreme Court did not need to displace Judge Koh and the Ninth Circuit's decisions. So this idea that Judge Koh's opinion was somehow outside of the mainstream is just plain wrong. Likewise, the idea that Judge Koh, a person of faith herself, she shared that with us today, that she's hostile to people of faith is simply ridiculous. Now, with that said, Judge Koh, is there anything else? I know there's been a lot of discussion about your decision in the Tandon case. Is there anything else that you'd like to share with the committee? Anything that you'd like to explain further about your decision here?
Well, just that at the time, I was basing my decision on the facts in the record and the precedent that existed at the time. And I was following the Ninth Circuit's analysis of looking at risk transmission evidence and looking at the Sixth Circuit decision, which was the only one that existed at the time that was not calling out houses of worship and calling out religious exercise specifically. And the Supreme Court did not enjoin that decision that said it's a neutral and generally applicable rule. If it applies to public schools, private schools, religious schools, it doesn't matter because it's generally applicable and it's neutral. And that's the precedent that existed at the time. I was following Ninth Circuit precedent. I understand that subsequent to my decision, and my decision was affirmed by the Ninth Circuit, subsequent to my decision that I relied on in the Ninth Circuit, the Supreme Court ultimately reversed that decision. But at the time, I was following the law.
Okay, thank you. And as you shared, you are a person of faith yourself. So can you just clarify for the record, are you hostile to the constitutional rights of people of faith, as some of my colleagues on the other side seem to be implying?
Not at all. I understand that the right to religious liberty is one of the most important and fundamental rights. It's one of the foundations upon which this nation was built. Thank
you. And in the time remaining, I do want to sort of take a step back away from this case in particular and acknowledge what several of my colleagues have acknowledged, and that's your remarkably low reversal rate. I know several have mentioned it today over the course, just to remind us of the numbers, over the course of more than 3,200 opinions and 270 plus trials. You've had to rule on everything from mundane discovery requests to blockbuster questions regarding intellectual property. Is there a particular approach or philosophy you take to ruling on such a wide array of cases?
I try to do my best to look at the record that is before me, to decide only the limited issues that are before me, and to apply the law fairly, and to issue opinions that lay out in full comprehensive fashion what my ruling is, what my reasoning is, why I'm coming out this way, so the parties understand how I've reached that decision, so the appellate courts can see how I've come to a conclusion.
Thank you. And if I may, Mr. Chair, just in closing, question more on the personal side. By all accounts, you've already had a tremendously successful judicial career. You're one of the most respected judges in the Northern District of California and have the opportunity to preside over consequential and challenging cases in this capacity. On account of your prior confirmation to be a district court judge, you already have life tenure on the federal court. So put another way, you really don't have to be here today. So let me ask you, why are you here? Why do you choose to be here? Why did you choose to subject yourself to yet another confirmation hearing for this opportunity to serve on the Ninth Circuit?
Let me just say that the job I currently have is an amazing job, and I have nothing but the utmost respect for my colleagues. Trial court judges have, frankly, the least resources in the system and have very large volumes with tight time constraints. So this is a job that I love. But if confirmed, I would love to contribute to providing clear guidance to trial courts. I think the perspective of someone who's been sort of on the ground trying to apply it in very quick trials and very, short time frame, compressed time periods is helpful. And I think that I would really love also to serve a role modeling function beyond, my district, beyond my state, and to go meet law students, go meet young lawyers all over the Ninth Circuit. That is something that I really look forward to.
So, thank you very much. Thank you, Mr. Chair.